So what am I doing today?
Well, I suggest that first of all, you sign the plea forms. The general wants him under oath admitting that he is guilty of both, prepared to do that. We're just not going to enter the judgments or not enter the plea until the 27th.
All right. Mr. Zurek, raise your right hand. Let's place you under oath. Thank you. State your full name for the record.
Tomasz Adam Zurawek.
Mr. Zurek, you are here today charged with one indictment, and then I've been handed something called a criminal information, and I want to go over your rights regarding the criminal information so that you fully understand. Under our Constitution, every person who is charged with a criminal offense that carries the possibility of incarceration has the right to have those charges reviewed by, and the evidence reviewed by, an independent body called the grand jury of that county. The grand jury operates in secret, and they review evidence, only one side of the evidence, but they review the evidence, and they make a determination as to whether or not there is sufficient probable cause to return a charge against an individual. If they do, it would be a true bill. If they find there's not sufficient evidence, then it would be a no true bill. That would then result in an indictment or a presentment that would be brought into circuit court, and you would then be prosecuted on that. Every person also has a right. Ask this lady to quit sticking her arms up in the back, please. You also have the right to waive that step in order to expedite the disposition of this case. If you do that, then you need to understand that it would be treated the same as if you've gone through the grand jury process, but you will be skipping that step. Do you understand all of that? You understand you have an absolute right to have them review the evidence, but you have a right also to waive it. So is that what you wish to do?
Yes, sir.
All right. Then in each of these cases that are now before the court, and I believe he's already signed that, in each of these cases that are now before the court, do you understand what you're charged with, and have you and Mr. Flanagan had a chance to talk them over and discuss the range of punishment you're facing as well as any possible defenses you might have?
Yes.
While it's indicated that you want to enter a plea of guilty to both of these charges, you understand you have a right to plead not guilty and to have a speedy and public trial by jury on all charges.
I do understand.
You understand that you would have the right to have a lawyer and to have one appointed if you could not afford your own lawyer.
I do have a lawyer.
But you understand you would have the right, absolute right to a lawyer. Do you understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything? Do you understand that? Do you understand that if you went to trial, you would be able to confront and cross-examine every witness the state called to testify against you, and you can bring in every witness that you want by using a subpoena?
I understand.
You understand at trial you would be presumed to be innocent until such time, if ever, the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
I understand.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
I understand.
And you understand you'd be presumed to be innocent, you wouldn't have to testify or prove anything? You understand all that?
Yes.
You understand that by entering these pleas of guilty, you are waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers have worked out with the state. You understand
Yes,
that?
I do.
But do you understand that that's going to be resulting in convictions that will be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime?
I understand.
Now, I've been handed a document called a Notice of DUI Punishment that sets forth all of the statutory requirements and provisions regarding the enhancement. In other words, that every conviction that you have makes the next conviction more severe, the punishment more severe. And it bears your signature. Is that your signature?
That is correct.
And did you go over this with Mr. Flanagan? Do you feel like you fully understand that?
Yes, sir.
All right. Then, do you understand everything I've explained to you so far?
Yes.
Do you want to waive your right to a trial and to an appeal by entering a plea of guilty?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
You understand that I can't accept your plea? Well, first of all, you understand if you plead guilty, the court of the state could ask you questions about this offense, and if you answer those questions under oath, on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if I determine you were lying under oath.
I understand.
You understand I cannot accept your plea unless I'm satisfied that you are guilty and that there are facts to support it.
Yes.
All right. Then, General, do you want to ask the questions that you feel like needs to be on the record?
Dr. Zerwick, were you involved in a car crash on March 31st, 2022?
Yes.
And that was a crash that occurred driving where you struck, I believe, a delivery driver at the intersection of Highway 46 and Beasley Drive in Dixon.
Yes.
And at that point, you were under the influence of alcohol.
Yes.
Okay, I believe you were 6'2", according to TBI. Does that sound correct?
Yes.
And then on May the 7th of this year, you were found at Lake Circle Drive after driving and having multiple glasses of wine. Is that correct?
Yes. Yes.
Okay.
Yes.
And you believe that you wrongfully thought that was your house, correct?
That's correct. Yes.
A doctor walked into court and made a shocking decision. Before accepting his guilty plea, the judge carefully explained every right he was giving up, including his right to a trial. Then came the key moment. Under oath, the doctor admitted he had been drinking before driving. Those admissions could change everything. What do you think about this case?
All right. Mr. Yeager, I'm sorry. Were we ready on Mr. Garton?
Yes, Your Honor.
All right. I've been handed a document indicating that Mr. Garton is prepared to enter a plea to counts 1 through 5 of this indictment, which will all be amended to a violation of Tennessee Code Annotated 3913-527, sexual battery by an authority figure, and receive a sentence of 4 years, split confinement to serve 1 year day for day, with credit for time served, then released to state probation for a period of 3 years. He would be required to have in-person reporting, undergo a psychosexual evaluation, and follow the treatment recommendations, have no contact with the victim, BB, and he would be on the sex offender registry as required by law. This would be concurrent with 2019 CR 155. Remaining charges would be dismissed. Mr. Garton, raise your right hand. Let's place you under oath.
Yes.
All right. State your full name for the record, please.
Joshua Andrew Garden.
Mr. Garton, you're here today on a multi-count indictment. You've heard me go over what the agreement is, but have you seen or been shown a copy of all your charges and talked them over with Mr. Yeager? You and he discussed the range of punishments you're facing as well as possible defenses you might have.
Yes.
Well, it's indicated that you want to enter this plea of nolo contendere. What that means is you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they tell me what their evidence would be at trial, and I'm going to use that evidence to find you guilty according to this agreement. Do you understand that?
Yes.
You also understand you have a right to plead not guilty to all charges and have a speedy and public trial by jury in this court.
Yes.
You understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you could not afford your own.
Yes.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything.
Yes.
You understand that if you went to trial, you and Mr. Yeager could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes.
You understand you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes.
You understand if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal.
Yes.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes.
You understand that that is going to result in multiple convictions, and those convictions are going to be on your record in the future to make more severe the punishment you'll receive if you are ever again convicted of a crime.
Yes.
Do you understand everything I've explained to you?
Yes.
Do you want to waive your right to a trial and to an appeal and enter this plea according to this agreement?
Yes.
Is your decision to plead guilty today, no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
You understand I cannot accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty.
Yes.
And I want you to listen as the state tells me what their evidence would be if this case went to trial.
Yes.
Agree with those facts, but do you understand that's what the state's evidence would be if you went to trial?
Yes.
You still wish to plead no contest?
Yes.
Are you satisfied with your attorney's services?
Yes, I'm actually,
Do you feel like Mr. Yeager's done a good job of representing you competently?
he's done excellent.
Mr. Yeager, do you know of any reason he should not enter this plea?
No, Your Honor.
Anything further from the state?
Judge, just for the record's purpose, the state has had in-depth conversations with mother, father, what they considered a grandparent of child BB. I've also had discussions with BB concerning the proof in this case, likelihood outcomes at trial, and this settlement was signed off on by mother, grandparent, and BB.
All right, then Joshua Andrew Garden in docket number 2025 CR 100, upon your plea of no contest to counts 1 through 5, in each of those counts, you are sentenced to 4 years in Tennessee Department of Corrections. In each of those counts, that 4-year sentence will be served on a split confinement to serve 1 year day for day, and then be released to state probation with credit for time served. The remaining 3 years of your sentence would be served in each case on probation. You are to undergo a psychosexual evaluation and follow the treatment recommendations, and there'll be no contact with the victim BB. You'll be on the sex offender registry as required by law, and then this will be concurrent with 2019 CR 155. The only question that's not yet been, it doesn't specifically state, and maybe I missed it, are these 5 counts all served concurrently with one another?
Yes, Your Honor. They are.
And I'm going to make that notation. So. All right, that's the judgment of the court.
Thank you, Your Honor.
Mr. Baker on State versus Jeffrey Ty Hicks.
How to resolve that one today?
And that's today.
We're going to try. And Judge, also if I can address the court, I submitted Ms. Selke's TBI.
The doctor admitted that alcohol impaired his judgment and caused him to mistake another person's house for his own. After confirming he understood his rights and the consequences, the judge scheduled sentencing for a later date.
Turns out it was not, correct?
That's correct.
Due to the impairment of the alcohol.
Yes.
All right, then at this point in time, I will ask you, are you satisfied with your attorney's services?
Yes, I am.
You feel like Mr. Flanagan's done a good job of representing you competently?
Yes.
Mr. Flanagan, do you know of any reason he should not enter these pleas?
No, Your Honor.
Then I will suspend the sentencing, or suspend this portion of this case until the 27th, and we will come back on the 27th of May and finish the disposition and sentencing in this case.
Just for the record, we will be moving the motion to revoke to that same day.
All right. Then we will set it for May 27th. All right, we've been through the docket once, all 59 pages. I'm going to go back through the second call, and then we'll take the jail cases. Do we have inmates up here? All right, let me run through these second calls, and then we'll take the inmates up. (2026) CR 90 State versus Nicholas Adam Butler. Mr. Mr. Butler, you were previously placed under oath, and you've indicated that you have no income. Is all of that information on this form true and correct?
Yes, sir.
Your bond was made by your mother.
Yes, sir.
All right, I find Mr. Butler to be indigent, and I will appoint the public defender to represent him. He was here for arraignment on a charge of evading arrest by flight by vehicle. So,
Acknowledge receipt of the indictment, waive formal reading, enter plea of not guilty at this time.
plea of not guilty is entered, set for status September the 8th. Twenty 2025 CR 256, Day versus Rodrigo Flores. Mr. Baker.
Need to talk to him about because it's got a jail component and substantial restitution. Can we move that to the September date?
Well, September, or
Put it on VOP of this day. Put it in the email with him. If we could do a VOP status date, see if we can resolve this. We'll work on it.
May 27th.
May 27th? Sounds good, Judge.
On page 20, 2025 CR 100, State versus Joshua Andrew Garton is in jail. But that's going to be for disposition, you said. Do we have Mr. Garton here? Let's go ahead and bring him out. Mr. Baker, I had a second call on one of your cases. You were out of the courtroom. State versus Marvin Christopher Harris. You've already filed a waiver of arraignment. All right, then do we want to set it for, I assume we just set it for September the 8th? All right, thank you. Well, my granddaughter goes to that church, to that school, so probably need to put that on somebody else's. Why don't we move that, Mr. Harris? Let's just move it to your, let's put it on Judge Turnbow's docket next. That would be in August. I'd say August, it's a VOP, is that correct? No, it's a violation. Let's put it on August 3rd.
A man entered a no contest
Indigency
plea
form to
in a
run
child
diversion
abuse case,
application.
choosing not to challenge the evidence against him. The judge sentenced him to 4 years, with 1 year in jail and 3 years on probation, and ordered him to register as a sex offender.
Mr. Atchison, have any other cases that need to resolve?
I don't know, but if you want me to sign something, you're going to have to lay hands on it and hand it to me. I'm a little busy, so. 2023 CR 420 State versus Terriana L. Holbrooks. Ms. Holbrooks, you have filled out this affidavit and you were placed under oath earlier. Is that all of that information true and correct?
Yes, sir.
If you have no income, how were you ever planning to hire a lawyer?
My mom and my granddad was going to help.
All right. I find that she is indigent and therefore is entitled to have a counsel appointed. Public defender. Maybe you should just read me the list of people who don't have a conflict of interest. Does Mr. Roger Wanick and Wanick Law Firm have a conflict? All right. I'm going to appoint Mr. Eric Locker of the Cheatham County Bar to represent this defendant. You have, has she already been arraigned? She has. This is status for attorney status only. Mr. Eric Lockhart is a member of the Lockhart Law Firm over in Ashland City. It'll be your responsibility to contact him and make an appointment to go in and see him. And in the meantime, have we set a status day on these cases that are conspiracy? September 8th is your next court date, so you need to make sure you go as quickly as possible to meet Mr. Lockhart so he can start working on your case, because September the 8th, we may be setting you a trial date. Okay? Thank you. (2026) CR 104, State versus Aaron James Kosurik. Mr. Wanick. (2024) CR 236, State versus Lacey Angelica Jordan Lackey. Mr. Baker.
I have just written up a plea sheet on her. We received her diversion back, and if you could second call that, or I guess third call that, we should have something.
Excuse me. 2021 CR 100, State versus Jacob Dakota Miles. Public defender asked for a second call.
On Mr. Miles's case, may we please go to the status date in September?
Let's do September 23rd, trying to spread out these
Yes, sir.
cases. September 23rd.
Thank you, Your Honor. All right.
And is Mr. Baker, State versus Jamie Allen Stewart, public defender.
One more time. We're about to get this done, but we just need a couple
All right.
The judge finalized the sentence. 1 year in jail, 3 years of probation, mandatory treatment, no contact with the victim, and registration as a sex offender. With that, the case came to an end, and the court moved on to the next defendant.